Mr Speaker.
Honourable David Parker.
Thank you, Mr Speaker. I rise to take a call on behalf of the Labor Party. I want to deal with a couple of issues that I think are less than perfect in the bill as amended at Select Committee. The Labor Party, given the changes that have been made and negotiated at Select Committee, will be supporting this legislation, and we do so in part because in respect of legislation which is intended to endure beyond governments and beyond the term of any one particular parliament, we think it's one of the roles of the main political parties in this House, who at times sit on government and opposition benches, to try and reach agreement as to framework legislation so that there can be continuity and certainty around those settings in a way that means that we have consistently applied standards in the state sector and the wider public sector. And with the changes that had been agreed at Select Committee, we find ourselves on balance favouring this legislation and supporting it through subsequent stages. Mr Speaker, there are a couple of things that I do want to refer to that I thought were pretty poor in the original legislation. For a start, there was a regulation-making power, effectively, that was conferred upon the Minister to give directions to chief executives which were so broad as to effectively enable by statutory regulation to allow the Minister by a directive which amounted or was akin to a statutory regulation to impose a wage freeze throughout the state sector. And as we said at Select Committee, that was akin to the regulation-making powers that National used to vote themselves and exercise under the old Economic Stabilisation Act, under which the then National Prime Minister, Mr Muldoon, inflicted upon New Zealand a wage and price freeze through statutory regulation. That's right. How did that go? Said Mr Williamson. It didn't actually go very well, Mr Williamson, and indeed it was as a consequence of the inept management of the economy by that particular government, National, led by the Right Honourable Muldoon, that led to New Zealand having the highest government debt that it's had since I've been born. And I think at one stage, $1.04 was being, of all taxes collected, was being spent on interest as a consequence, and debt was out of control. And of course, subsequent governments, be they firstly Labor and then National, and then Labor again, and reduced government debt very substantially, so that by the time the government that Mr Goldsmith now forms part of came to power, New Zealand had zero net debt, and gross government debt had gone from 40% of GDP, or 38% of GDP, down to 18% of GDP. And so it was, in fact, the responsible fiscal management of the last Labor government and the prior two governments, the prior National and prior Labor governments before that. That meant that New Zealand was in a position, come the global financial crisis, to actually see things through in a way that didn't cause the downward spiral that's been experienced in other countries that have had declining economic circumstances at the same time that they've had to pursue austerity on the government books. Mr Speaker, there are a couple of other things. That regulation-making power has been severely narrowed in this version of the bill, and as a consequence that particular detriment of the bill has been remedied. I want to go a little bit further into two things. One is how you've got to be very careful not to cause unintended consequences when you change foundation legislation, and there are a number of occasions where this is happening at the moment in the law. The government has modified its position in respect of whether people who move from one position to another in the wider government service can be effectively pushed into a new job and lose their existing rights under their employment contract, or their collective agreement. They have often redundancy provisions which they were going to lose under the version of the bill that went through first reading and went to Select Committee. And now the government's agreed to change that so that now for people to lose their entitlements, they have to accept a position that is no less favourable than their existing package, and that's a fair enough outcome. But there's another area where the government's causing an unintended consequence at the moment. That's the changes to the Employment Relations Act. Under that legislation, and this is actually dawning upon the business community at the moment, that that legislation is so ideologically driven, notwithstanding the fact that New Zealand has had very low rates of industrial disputes. The changes to the employment relations legislation that the government's they're actually going to increase the number of strikes and lockouts. And the reason for that, which was explained to me recently by an employment lawyer, is quite simple. Under the new employment relations bill, people lose their right to strike or lockout once the negotiations are deemed to have been broken down. And once you reach that point of breakdown of negotiations, and they are deemed to have broken down, you can't strike or lock out. Which means that if you are an employer that wants to lock out or an employee that wants to retain the right to strike, you've got to do it before you reach the point that your negotiations have broken down in this new deemed definition of a breakdown of employment relations. And that must mean, it logically must mean that as a consequence, we are going to see more industrial disputes move to lockout or strike earlier. So this ridiculous piece of legislation, the Employment Relations Act, that the government's bringing through, in the context of very low rates of industrial disputes that turn into strikes or lockouts, the government's own industrial relations legislation is going to make it worse, because people lose the right to strike or lockout once they pass a certain point, and therefore, in the context of those negotiations, which sometimes are protracted, they're going to have to exercise their right to strike or lockout earlier in the process before they lose the right to do so.
Come back to the bill.
So, Mr. Speaker, it shows how careful we have to be with legislation, that we don't make things worse. Mr. Speaker, another area of this legislation that concerns me, and I don't think we have got it right yet, is at Clause 54 of the bill we've got a Section 86 which is protecting public service chief executives and employees from litigation. Now, I for one think that where someone is acting on behalf of the Crown, they're going about their business and their job and they make a mistake, then they ought not to be the one that actually faces liability for the consequences of that mistake. The Crown stands behind them, and it's the Crown that wears the loss in respect of a problem that is caused to a member of the public who has a right of action. I have no problem with the members of the public service being protected from liability in civil proceedings for their mistakes. So that's not what this debate is about. This debate is about whether they should be protected by way of having an indemnity from the Crown or whether they should have an immunity. And this legislation, according to the Law Commission and the Law Society, goes too far by conferring immunity. And what the Law Commission said is that we're effectively creating, and they use this phrase, a faceless bureaucracy who cannot be brought before court. Now you think, well, what's the consequences of this is? Well, the consequence is that you could actually have someone who, in good faith, does something that's grossly negligent, which means that because of the wording of this, which gives an immunity from civil proceedings, so long as something is done in good faith, it could be grossly negligent, and yet the injured party out there in society will have no right of suit. They won't just have a right of indemnity from the Crown, they will have no right of suit. So the injured person in society, the powerless person who has suffered a gross act of negligence on the part of an arm of the state through a public servant, is left without remedy. That is wrong. That is actually going a step too far. What we should be saying is that the employee who makes that mistake is indemnified against liability, but we shouldn't be giving immunity so that the person who is injured by an arm of the state has no remedy. Now, we tried to change that at Select Committee. The Labor Party said that that was wrong. We thought the Law Commission had it right. There are occasions where the Crown will not be vicariously liable for the acts of the grossly negligent an employee, because vicarious liability will not cover the action, and the injured private citizen injured by an arm of the state through an act of gross negligence will be unprotected. That is wrong. The Law Commission said it was wrong, and the national government refuses to fix that aspect of the law. Mr. Speaker, this legislation is imperfect. But overall, it's important housekeeping legislation, and we will be supporting it at this stage.
Denise Roche.
Thank you, Mr. Speaker. I rise to take the first call on the State Service